Good morning, everybody. Welcome to the Brick Court Chambers webinar, Jurisdiction Jousts After Brexit, More Conflicts Ahead, ? My name is Richard Aikens. I'm a retired Court of Appeal judge. I now work at Brick Court Chambers on international arbitrations. But for my sins, I am also one of the editors of Dicey and Morris and Collins on conflicts of laws. And it's going to be my task to have to rewrite the chapter on jurisdiction. So I'm particularly interested in this morning's seminar. For many of us, the jurisdiction regime established by the Brussels Convention, the Brussels Regulation, and then the recast version has been the key, or at least a key, jurisdictional textbook for all or most of our professional lives. I'm old enough to remember the old Rules of the Supreme Court Order 11 regime before the UK adhered to the Brussels Convention, but most of you won't. Now times are changing again. Lawyers are not really very good at change, I think, but we are going to have to learn fast. This seminar is intended to help you make a start. Charlotte Thomas will start off by explaining the new framework after Brexit. She will explain the transitional regime, the prospect for us joining Lugano, and some key aspects of the new regime. Daniel Jowell QC will then focus on exclusive jurisdiction clauses with a counterparty in the EU. He'll outline some of the key requirements of the Hague Convention on Choice of Courts and the new provisions for service out. Jacob Rabinowitz will follow, outlining the key principles governing the grant of anti-suit and anti-enforcement injunctions at common law. Finally, Stephen Midwinter will discuss how, under the pre-Brexit regime, anti-suit injunctions weren't granted in respect of proceedings in EU member states and what sort of skirmishes we can expect in the future. Please post any questions you have, and we will try and address them at the end of the presentations. Now, Charlotte will start. Her practice covers all kinds of commercial dispute resolution, competition and European law, and commercial judicial review, with particular experience in energy, financial services, and pharmaceuticals. She retains a keen interest in conflicts and jurisdictional issues dating from her postgraduate studies in both in England and the United States, and most of her cases include a cross-border element. Charlotte, over to you.
Good morning, everybody. Thank you so much for joining us to talk about Brexit on a sunny lockdown morning, and thank you very much to Sir Richard for the introduction. As you've just heard, I'm going to take the issues broadly chronologically. So as the slide in front of you is hopefully showing, yes. I'll first talk about what we've left, which I'll take very quickly, but I'll just recap what it is that we're leaving to get us warmed up. Next, the question is, what are the transitional arrangements? Next, and perhaps most pressingly, where are we now? What's the same? What's changed? And finally, is there a prospect of further change, in particular, further cooperation in the future? So before diving in, where are we? What are we leaving? What are we leaving? Next slide, please. So currently, and this again will hopefully be very obvious to everyone in this webinar, EU jurisdiction rules are governed by the Brussels Recast Regulation, which replaced the previous arrangements as you see on the slide, previously Brussels I and previously the Brussels Convention. That's the Complas in Brussels in the corner. You'll see a theme with the pictures on the slides. There exist also further bespoke arrangements in the form of the Lugano Convention, which is entered into with the Iceland, Switzerland and Norway states, and the EU-Denmark agreement. And just to remind you, since we're obviously going to be talking a bit more about the Lugano Convention in particular later, the Lugano Convention broadly reflects the provisions not of the Brussels Recast Regulation, but of the previous 2001 Brussels Regulation. Next slide, please. So I'm going to show a beautiful flowchart setting out the operation of the current Brussels recast regime, for which I must give primary credit to my colleague Ed Ho, though of course any mistakes are mine. While we have this slide up, I'm just going to pause very briefly on 3 points which are of special relevance to the Brexit situation, which I hope are familiar and that you see listed on this slide. That's the scope, in particular the exclusion of arbitration, second, the treatment of jurisdiction agreements and vis alibi pendens, and thirdly, the centrality of domicile. So if we go to the next slide, it should have this beautiful flowchart setting out how it all works. So as I say, the first thing to pause on is to note that Article 1 expressly excludes arbitration from the scope of the Brussels regime, as you no doubt know. I think one of the things you may be hearing about later is the possibility of issuing anti-suit injunctions, including anti-suit injunctions in support of arbitration proceedings, and how that operates under the Brussels regime. Second is jurisdiction agreements. Again, you're going to be hearing a lot more about these later, but for the moment, I just wanted to pause and underline some important differences between Brussels recast and Lugano. First, as you can see on this slide, which I'm afraid has been cut off slightly at the sides, but hopefully you can see, under Brussels recast, we're told the court must stay the claim where there is an exclusive jurisdiction agreement in favour of another member state court, but not where there's such an agreement in favour of a third country. The regulation is simply silent on third country agreements. Instead, as you can see in the bottom right, you look to Articles 33 and 34, which apply only where the third state country has already been seized in order for a discretion to decline jurisdiction to arise. That has obvious relevance now that the UK is a third state. Now that position is still an improvement over Lugano and Brussels 1, where the jurisdiction agreement provisions first of all were only engaged where at least one of the parties was a member state domiciliary, and secondly were not even engaged in respect of third states at all, which led to the development of a sort of unsatisfactory theory of reflexive effect, which again I think you're going to hear more about later. Finally, under Lugano, even if there is an exclusive jurisdiction agreement in favour of, say, the English court, when England was a member state, when the UK was a member state, if another member state is seized first, it's necessary to wait for that member state court to determine the position and decline jurisdiction in favour of the member state in whose favour there exists an exclusive jurisdiction agreement. That led to the sort of famous problem of the Italian torpedo. The Brussels recast regulation got rid of that problem and allows the member state court in favour of whom there's an exclusive jurisdiction clause to proceed without waiting for the court first seized. And the final point to pause on is the centrality of domicile. Although it comes quite far down in the hierarchy, it is the general rule under what's now Article 4, which is that a defendant should be sued in its domicile, giving general jurisdiction unless any of the other provisions apply. Of course, it's actually often very beneficial for claimants to have a cast iron basis for suing someone as an anchor defendant. The Group QC case confirmed the application of the domicile rule even where a claimant's not domiciled in a member state, again of special relevance to UK parties, now the UK is a third state. Then in the very well-known case of Owusu, the Court of Justice confirmed that where jurisdiction is taken under the Brussels-Lugano regime, that applies to the exclusion of domestic law. So that means you can't make a forum non-conveniens challenge under the common law, even where the state, which is said to be more appropriate, is not a member state. That obviously creates some problems given the inflexibility of the Brussels-Lugano regime vis-à-vis third states, which I've just talked about. I finally just noted there the recent Vedanta case in the UK Supreme Court, which slightly lessens the anchor defendant deadweight in non-Brussels cases for defendant groups who are willing to submit to another jurisdiction. So that's what we're leaving. Very quickly whistle-stop tour, but as I say, I hope all of that is a reminder. We were then, of course, until quite recently, in a transitional period until the 31st of December 2020. And so the question is, to what extent are those transitional provisions still relevant? Well, first of all, just to confirm in the next slide, the deal addressed choice of law by Articles 66 and 67, confirming that the Rome regulations were continued to the extent that they applied. It's interesting to note that the transitional provision in respect of the Rome II regulation doesn't actually match up with the rule that's actually contained in Article 4 of the Rome II regulation, but that may have limited relevance, as we'll see, since we've in fact continued to apply Rome II. The next slide is a little busy, I'm afraid, but I thought it helpful to get everything in one place. So these are the transitional provisions in respect of jurisdiction, recognition, and enforcement of judgments. So the withdrawal agreement confirms that the relevant provisions of the Brussels regime will continue to apply to judgments given in proceedings instituted before the end of the transition period. And that's under Article 67, which deals with Brussels recast. Article 69.2 does the same thing for the Denmark agreement. And then the same goes for the Lugano Convention, but only by implication under Article 129, which continues the UK's membership of international conventions during the currency of the transition period. So, for these purposes, it doesn't matter when judgment is given, the Brussels recognition and enforcement regime will continue to apply in respect of English judgments as long as the proceedings are begun in time. And we've had very recently confirmed in the 2020 regulations, as you see right at the bottom of the page, that the decisive thing for the purposes of the CPR is whether proceedings were issued, not whether they were served before the 31st of December 2020. So that we've been told what institutes means for those purposes. There's another little wrinkle in the savings provisions in the relevant Brexit statutory instruments, which probably just give us a preview of the sort of complexity that we may be seeing in the litigation on this point. And one has a great deal of sympathy for the poor parliamentary draftspeople who have had to deal with all of this. So Regulation 93.2 of the 2019 regulations suggests that where the UK court has seized jurisdiction before 31st of December 2020 and proceedings are subsequently instituted in a member state court, the UK court may decline if and only if it's unjust to do so. Well, of course, we've just learned from Owusu, as I just explained, that there isn't any discretion to decline jurisdiction like this under the Brussels regime, simply because you think the second seized court might be better. And then conversely, Article 31 of the Brussels recast regulation again mandates declining jurisdiction by the first seized court, where the second seized court has an exclusive jurisdiction agreement in its favour. Again, there's no space for a discretionary decision to be taken in that situation. So the 2020 regulations somewhat correct this by saying in Regulation 5 that nothing in the 2019 regulations is intended to affect the withdrawal agreement. And I should say there it especially refers only to Articles 67 and 69 of the withdrawal agreement, which of course concern the Brussels recast regime and the EU-Denmark agreement. So it doesn't refer expressly to Article 129, which continues our membership of the Lugano Convention. So possibly this provision will only be relevant to Lugano. It's not totally clear what it's intended to achieve. It may be that it only affects a very small number of cases, but where it does, it's obviously quite an interesting question. Next slide. I won't spend any time on this in this talk, but just to note that the transitional agreement continues membership or continues the effect of the service and taking of evidence regulations. And in both cases, they apply where requests were received before the end of the transitional period. So they may still be of benefit to parties who got their requests in under the deadline. So those are the transitional rules. The next question is, where are we now for new cases going forward? We're in the brave new world of Brexit actually having happened, but some things have stayed the same, as I've listed out on the next slide. The first thing is that I think we can all breathe a sigh of relief that choice of law rules have stayed the same, at least where they apply. For example, the UK Supreme Court in Enker and Chubb recently confirmed that it's the common law rules that apply in respect of agreements to arbitrate. These regulations are continued as retained EU law under Section 3 of the Withdrawal Act. And of course, they've been amended to ensure that they can be localised. Because they're retained EU law, that might create some wrinkles, especially going forward to the extent that there's any divergence. So they have to be interpreted in accordance with Section 6 of the Withdrawal Act as retained EU law. Of course, no reference to the CJEU is possible. And also, of course, the Supreme Court, and I understand also they're changing it so that the Court of Appeal will also be able to depart from existing CJEU case law. As to future CJEU case law, English courts may have regard to it if they consider it appropriate. It's hard to think that English courts will sort of set their face against CJEU law just for the sake of it, but it does open up the possibility of divergence. I'd also just note there's a reference to non-derogable EU law in Article 4 in particular, of the Rome II regulation, which again, that may be a sort of possible space for divergence, as member states may take a different view as regards what amounts to non-derogable EU law. The next thing that hasn't changed is that the Brussels rules on consumers and employees have been retained by way of amendments to the 1982 Act. And the next thing that's changed is that hasn't changed, sorry, is that the Brussels regulation will of course continue to be relevant to UK parties for some of the reasons that we've mentioned. Note the sort of fairly broad definition of domicile for companies, which may mean that some companies may be treated as having multiple domiciles, not only in the UK but also in an EU member state. And further, Article 6 of the Brussels Recast Regulation lists out the situations where a UK defendant might be dragged to court in an EU member state, usually for perfectly sensible reasons: EU consumers being able to sue UK companies, exclusive jurisdiction agreements and so on, which you'll also hear about. And also, of course, as mentioned, UK claimants can continue to sue EU defendants by making use of the Brussels recast regime under the rules in Group JOSI. So that's all a little, I don't know, not very promising for English lawyers perhaps, who will no longer be able to advise on the workings of the Brussels regime in this regard. I suppose there may be a niche practice for those of us with newly minted Irish qualifications, but it's also not terribly surprising. The next couple of bullet points I include to cheer us up a bit, maybe. The first is that, well, of course, the reasons why parties litigate in English courts are, well, I understand, or for the most part, it seems to be the English common law and procedural rules which attract litigants to London, and of course our excellent judges, as Sir Richard will know. And another reason is the surfeit of high-quality commercial practitioners. So you can also all hopefully feel warm inside about that. And then the fine point is that arbitration will not be affected, because, as we've seen, the Brussels recast regulation scope does not encompass arbitration. And you may hear later that there may in fact be further possibilities of issuing injunctions in support of arbitration, as mentioned. So that's what stayed the same. I'm attempting to ground us in some familiar territory, but of course a lot has changed, which is the next slide. So the current position is effectively that there's been no deal on jurisdiction and judgments. And so the no deal regulation from 2019 has gone through. The effect of that is that the Brussels and Lugano regimes have all been revoked going forward. We fall back on the common law. And this is all explained in a Ministry of Justice notice issued late last year. So as the next slide explains, that of course means much wider use of CPR Part 6, with permission being required to serve out, whereas until December 2020 there was no requirement to seek permission to serve out in Brussels and Lugano cases. So we do still have some exceptions to fall back on under CPR 633. The first is the consumer and employment cases under the 1982 Act that we've seen already. The second is Hague Convention on Choice of Court agreements that you're going to hear a lot more about from Danny. And the third is a forthcoming amendment with effect from April in situations where a contract contains a term to the effect that the English court will have jurisdiction to determine the claim. So there's a new exception where you won't require permission to serve out in such a case. Next question is recognition and enforcement. We, of course, for incoming judgments, have the common law rules in respect to the recognition and enforcement of foreign money judgments. So in this next slide, I'm thinking really about how we get English judgments enforced abroad and how the situation has changed there. So where it applies, the Hague Convention on Choice of Court may be of some assistance. And there will also be, I've just sort of mentioned it because it's out of interest, there is a new Hague Convention on the recognition and enforcement of foreign judgments, which will apply more generally and not only in choice of court cases. But the signatories so far are only Ukraine and Uruguay, so it's not got off the ground just yet. There are, interestingly, some very old bilateral agreements which technically could revive themselves, and that I've listed out here. They apply only in respect to money judgments, and they're incorporated into UK law under the 1933 and 1920 Acts. Norway has confirmed that it intends to revive that old treaty with some tweaks, hence the beautiful picture of Bergen in the corner. Of course, those rules are very attenuated compared with the Brussels regime, and where there's no treaty, one is simply dependent on the rules of the foreign country's private international law. So the scope for reliable international agreements to enforce English judgments is obviously reduced compared with the Brussels recast regime. I'll just pose the question as to whether that's a real concern, but obviously it will depend on every case as to what the particular situations are and what the enforcement concerns are. One thing to note in particular is that not being bound by EU rules may leave English courts freer to make orders to support the enforcement of their own judgments. It had previously been doubted whether under the Brussels recast regime it was possible for English courts to issue orders such as investigation or disclosure orders in order to provide practical assistance with the enforcement of English judgments. And it's now clear that obviously they can under the common law, and so that may actually be a positive boon to the practical enforcement of an English judgment. The next slide deals very quickly with evidence of service. Again, I've not proposed to go into that today, but just to note that we have the Hague Conventions there as well. And there are some CPR provisions, in particular CPR 640B, which permits service by any method permitted by the law of the courts in question, which may assist in some cases. Slide 14, so back to the common law, which obviously we are used to dealing with in respect of non-EU cases, but will now become a much more significant part of practice. Again, in an attempt to cheer us up a little, it does seem to me that there are some advantages to relying on the common law. First of all, we can keep the bits of EU law that are good, in particular the choice of law rules, as retained EU law. And in relation to jurisdiction, there are some advantages to the common law regime. I've mentioned here a talk given by Professor Briggs a couple of years ago, where he rather charmingly talks about the common law as being a loose-limbed rather than long-arm regime. And it's that flexible nature that does often appeal to litigants. In particular, there are various rules under the CPR as well, which suggest slightly broader and more flexible jurisdictional approach, where the English courts are permitted to apply the common law. One is, for example, the mosaic principle problem created by Article 7.3 of the Brussels recast regulation. The question of the meaning of damage under the applicable jurisdictional gateway under the CPR Practice Direction 6b has already been considered obiter by the Supreme Court in the Brownlee case, and there's been a further appeal just heard in January of this year, where that will be elaborated upon. There are also somewhat broader jurisdictional gateways, such as being able to take jurisdiction over claims arising out of closely connected facts or out of any contract governed by English law, even where there's not a jurisdiction agreement. And also, of course, as we all know, it's more flexible in being able to apply the foreign convenience rules, and also in the fact that the Rules Committee can respond more rapidly by, as we've just seen, inserting new jurisdictional and other gateways into the rules in order to respond to whatever our new litigation needs are. That kind of flexibility obviously isn't available where you have to agree with so many other countries. Final question is, I've noted the possibility of more antecedent injunctions, which you're going to hear about later. So the final question is this rumour that we may apply or may be accepted into the Lugano regime again, and this is the next slide. So the UK government has applied to rejoin the Lugano Convention. The application was lodged in April last year and placed before Parliament in November. If and to the extent that this ever happens, there will be a 3-month accession period. The mood music, as I understand it, is that it's doubted whether this option will be made available to us by the EU Commission, because it takes the view that the Lugano regime is for single market countries, which of course all of the current Lugano members are. It's technically possible under Article 70 of the Lugano Convention, but that seems to be really for Switzerland, which is of course highly integrated into the single market. I would only say, who knows really? This whole saga, I think, has told us that anything is possible. And in particular, the situation on the island of Ireland may need some resolution, because it's difficult to have different regimes for service providers on the two parts of the island. So that's one issue that may prompt reconsideration. I understand that the word on the street is that the Commission is due to respond by the end of March. If anyone who is listening has any further intelligence, do please share. And then by this final slide, before I hand over, I'm just going to pose the question whether Lugano is actually the way forward. There might be a better solution. There are obviously very significant advantages of continuing under the Brussels-Lugano umbrella. There's sort of stability, continuation of what we know already. As Sir Richard said, lawyers don't always like change. It's more efficient, there's benefits in terms of enforcement, and for that reason it's recommended by very many serious commentators. But there are, of course, downsides of the regime. In particular, the role of the CJEU may be difficult in circumstances where our courts are unable to make a reference to the CJEU, but end up having to follow or at least take account of CJEU judgments without any control in the institution itself. And there's also the downside of lack of participation in future reform. The UK was very active and involved in effecting the reforms to the Brussels recast regulation, which favoured exclusive jurisdiction agreements, as we've seen. And obviously that ability will be diminished. And finally, there's the point that, as I've sought to emphasise a little bit during this talk, the Lugano regime is deficient compared to the Brussels recast regime in various respects. So it seems very unsatisfactory for us to have to go back from Brussels recast to the Lugano regime. I wonder if in due course there mightn't be a possibility of a negotiated solution. So with that possibility hanging in the air, I will hand over back to Sir Richard and to Danny Jowell QC, who's going to talk, I think, about exclusive jurisdiction agreements.
Thank you very much indeed, Charlotte. Well, I personally think that there are a lot of disadvantages with Lugano for the reasons that you've given, but that's later in the discussion, perhaps. Now, Daniel Jowell took silk in 2011. He practices across all aspects of commercial law and in competition law. He's appeared in over a dozen reported judgments involving challenges to jurisdiction over the years, including the recent Privat Bank and Al Rajan cases. Daniel.
Thank you, Sir Richard. I'd like to start, if I may, with the first, if we could have the first slide, please, with a familiar scenario to many of you. Your client has entered into a contract. The counterparty to the contract is domiciled in an EU member state. Let's say, for example, they're domiciled in Italy. The contract contains an exclusive jurisdiction clause in favour of the English High Court, and a dispute has arisen. Your client is concerned that the other party, the Italian party, may ignore the exclusive jurisdiction clause and choose to sue first and seek to obtain jurisdiction in Italy. And your client comes to you and says whether they can rely on the English exclusive jurisdiction clause, whether in Italy or over here. Now, what advice do you give in our brave new world? I'd like to start, if I may, with the Italian position. So if we could have the next slide, please. Now, as Charlotte mentioned, before Brexit, your client could rely, both in Italy and in this country, upon Article 25 of the Brussels regulation recast. That's the provision that provides for jurisdiction in the case of exclusive jurisdiction clauses in favour of the courts of a member state. And Article 25, in combination with Article 31(2) of the Brussels regulation recast, effectively trumps almost all of the other grounds on which a party can establish jurisdiction under the Brussels regulation, including domicile and place of contractual performance. So before Brexit, you ought to have been able to rely on the Italian courts staying proceedings in favour of the UK. But there is now a hitch, because the UK, of course, is no longer a member state, but a third state. And so Articles 25 and 31(2) no longer apply to it. Now, it used to be the view under the old Brussels Convention and Regulation, and it still is, I think, the dominant view in relation to the Lugano Convention, that doesn't necessarily matter, because the regulation could be applied reflexively. Now, what's meant by applying it reflexively is essentially that an individual member state can apply its own national law by analogy with Article 25. So on the reflexive approach, Italy could apply its own national law to uphold the exclusive jurisdiction clause in favour of a third state like the UK. And it could do so in the same circumstances where Article 25 would apply if the exclusive jurisdiction clause had been in favour of an EU member state. But the ability to rely on a reflexive application under the Brussels regulation recast is very much in doubt. And that is because the express provisions in Articles 33 to 34 of that regulation arguably now constitute an exhaustive code in relation to third states. And those articles only cover the position of pending proceedings and not exclusive jurisdiction clauses alone. And so, at least in this country, in one case that's on the slide, Gulf International Bank and Aldwood, the court concluded that this position meant that there is no longer any room for reflexive application in relation to exclusive jurisdiction clauses in favour of third states. Now, of course, we don't know for sure whether other EU member states will take the same view. We don't know whether Italy would take the same view in my example. But we would have to, ultimately, you'd have to take Italian law advice on that issue. But what can be said is that it is very far from clear that a jurisdiction clause in favour of the UK would now be enforceable under the Brussels regulation recast. And if that's right, there is a risk that the Italian counterparty might be able to ignore the exclusive jurisdiction clause and sue in Italy on some other ground, for example, because the contract was to be performed there. Now, there is something that may come to your rescue in a situation like this one with an exclusive jurisdiction clause, and that is the Hague Convention on Choice of Court Agreements. If we could have the next slide, please. Now, the EU acceded to the Hague Convention from the 1st of October 2015, and all member states, and which included at that time, of course, the UK, were therefore bound from that date. And the UK has now in its own right acceded to the Hague Convention from the 1st of January this year, a position that is reflected in statute. So in principle, the Hague Convention applies where the state of the court seized and the state of the court chosen to have exclusive jurisdiction are both parties to the convention. So it might apply in the England-Italy example that I gave earlier. But the Hague Convention has a number of limitations. And so to illustrate some of those limitations, I'd like to put a bit more flesh on the bones of the example that I gave earlier. So let's suppose, as we see on the slide, that your client, the English company, entered into its contract with the Italian company in September 2014. And it did so for the transport of goods from England to Italy. And the contract in question contains an exclusive jurisdiction clause, but of a particular type, what's called an asymmetric jurisdiction clause. So the Italian company can bring proceedings only in the English High Court, but the English company can bring proceedings either in England or Italy. And now, just to keep the competition lawyers amongst you interested and on your toes, let's add into the mix and suppose that your client wants to bring a claim not only for breach of the contract, but also an allegation that the Italian company is abusing its dominant position and that the contract is void on that ground. Now, on those facts, there are at least 3 independently sufficient reasons why the claim in relation to the contract I've posited would fall outside the Hague Convention. We could have the next slide, please. Now, the first reason is timing, because in the example I posited, the contract was entered into in September 2015, but in fact, the earliest that the Hague Convention applies is to contracts entered into after the 1st of October 2015. Now, interestingly, the Commission has suggested that the Hague Convention will only apply to English jurisdiction agreements entered into after the 1st of January 2021. In other words, from the date after the UK acceded in its own right. Now, it's not quite clear on what the basis the Commission takes that view or how seriously to take it, but there is at least a risk that an Italian court, for example, might consider that that is something that it finds influential. And so there is a risk that any jurisdiction clause in favour of the English courts entered into after the 1st of January 2021 might not be regarded in another EU member state, such as Italy or anywhere else in the EU, as not falling within the Hague Convention. Now, coming back to our example, another reason why in the example that I posited, the exclusive jurisdiction clause probably wouldn't fall within the Hague Convention is the nature of the exclusive jurisdiction clause. And that's because, according to the authoritative Jowell-Hartley report, the Convention does not apply to asymmetric exclusive jurisdiction agreements. Now, it's important to note that that report is pretty authoritative because it was approved by the participating states in the Hague Convention conference that created the Hague Convention. So it's got real weight. Now, there are two judgments of the English High Court that you will see on the slide, Commerce Bank and Etihad Airways, where English High Court judges have expressed the view that there are good arguments to the contrary, in favour of the idea that even asymmetric jurisdiction clauses may fall within the Hague Convention. So we'll need to see where that ends up in this country, but certainly that's not what the Jowell-Hartley report says. Now, the third reason why, on the example I posited earlier, the claim wouldn't fall within the Hague Convention is because Article 2 of the Convention has a number of exclusions that go beyond those that are in Brussels and Lugano. For example, one of those of those exclusions are contracts for the carriage of goods. So it wouldn't apply, in my example, to a contract for the carriage of goods from the UK to Italy. Now, another one of those subject matter exclusions to the convention are competition or antitrust claims. So it's tempting to think that a claim that a contract is void for abuse of a dominant position would therefore fall outside it. But interestingly, perhaps for the competition lawyers amongst you, that type of claim actually probably is within the Hague Convention. That one can get that from the Hartley-Jowell report, which says precisely that. And I'm prepared to give a prize to the first person who can write in and identify where in the Hartley-Jowell report claims it stipulates that claims for avoidance of a contract on the grounds that it is an abuse of a dominant position fall within the Hague Convention. I would say that the prize is a bottle of champagne, but I think in circumstances it should probably be English sparkling wine. But coming back to the substance, to sum up, the Hague Convention may or may not come to your rescue in the case of any particular exclusive jurisdiction clause. You need to check when the exclusive jurisdiction clause was entered into. You need to check what type of exclusive jurisdiction clause it is. Is it a non-exclusive jurisdiction clause? Is it an asymmetric jurisdiction clause, for example, because they probably don't fall within the scope of the convention. And you also need to look at what is the subject of the contract and what is the type of claim that you're planning to bring. So what then if your client is concerned by all of this considerable uncertainty and wants to issue proceedings first against the Italian counterparty and to do so in England? Well, the first thing it needs to think about is whether it needs permission to serve out of the jurisdiction or whether it can serve out without permission. And if I could have the next slide, please. Now, at the moment, the CPR rules permit service out without permission only where the exclusive jurisdiction clause falls within the Hague Convention, in the case of exclusive jurisdiction clauses at least. And when you don't have a Hague Convention compliant exclusive jurisdiction agreement, then you have to apply for permission to serve out, and you have to meet the three requirements of effectively a reasonable prospect of success. You have to fall within one of the gateways, and you have to establish forum convenience. But as many of you will know who've experienced the process for serving out, it can be quite burdensome, and it's got real disadvantages, not least because it imports an obligation of full and frank disclosure, which means that you will have to reveal the impending defences to your claim, which is never a comfortable thing for a claimant to do. But the great news is that as from the 1st of April this year, as Charlotte mentioned, thanks to an amendment to the CPR, we now have a new CPR 6.33 2b little b. And this new provision permits service out of the jurisdiction whenever a contract effectively contains a jurisdiction clause in favour of England. And that is it is a widely worded provision that would seem to apply to all English jurisdiction clauses and not just exclusive ones, and regardless of when they were entered into. And it would apply not just, of course, in relation to service on defendants within the EU, but also defendants wherever they may be domiciled across the globe. So it's much broader than exclusive jurisdiction clauses falling within the Hague Convention. Now, it's right to say, of course, that being able to serve isn't the same as obtaining jurisdiction. And if I could have the final slide, please. And so even where you've served out without permission, the defendant could still potentially challenge jurisdiction under CPR 11 and argue that England is not the forum conveniens. But the good news is that where you have an exclusive jurisdiction clause in favour of the English courts, ordinarily the English court will respect it. And indeed, even a non-exclusive jurisdiction clause creates a strong prima facie case that England is the appropriate forum for the resolution of a dispute. Of course, even if you do obtain jurisdiction for your client by issuing in England, it's possible that the other side in Italy may issue in any event. So you may have two competing sets of proceedings. And in those sorts of circumstances, if you've sued here in England first, you can go to Italy and try and rely on Articles 33 or 34 of the Brussels regulation and try and get the proceedings there stayed. But of course, that's entirely at the discretion of the Italian court. And if you have sued second in time, you can't rely on those proceedings at all. And so in those circumstances, you're going to need to consider whether you want to apply for an anti-suit injunction. And so on that note, I hand over to Jacob and Stephen to discuss just that. Thank you.
Thank you very much indeed, Daniel. Well, you've set Jacob up in position perfectly. Jacob is one of our two newest tenants in Brick Court. He studied history before completing the GDL, and he worked as a judicial assistant in the Court of Appeal before he came here. He's in the process of building, quickly but assuredly, a practice in commercial and competition law. So, Jacob, what about anti-suit injunctions?
Thank you, Sir Richard. As has been mentioned, Stephen and I are going to close off the seminar by discussing anti-suit and anti-enforcement injunctions. With the Brussels regulation now part of the past and the Lugano regulation only a possible part of an uncertain future, much of our focus at present should be on the common law. And with that in mind, Stephen and I plan on discussing anti-suit and anti-enforcement injunctions as follows. I'm going to set out an outline of the key principles governing the grant of these types of injunction at common law, and that will hopefully tee up Stephen's discussion as to, first, why under the pre-Brexit regime, anti-suit injunctions weren't granted in respect to proceedings in EU member states, and second, most importantly, what we can expect in the future. If I could have the next slide, please. Having promised to set out the relevant principles, as a former history student, as Sir Richard mentioned, I thought I might begin with a very quick discussion of the historical origins of the jurisdiction of the English court to grant anti-suit injunctions. This is not so much because that history is particularly relevant today, but rather because it's actually just interesting in its own right, and because also if you drop off the talk now, you won't know when to rejoin for the helpful part later on from Stephen. Anti-suit and anti-enforcement injunctions have been used in this jurisdiction since the late 14th century. We've become used to thinking of anti-suit and anti-enforcement injunctions as a tool used by courts in one country to restrain an individual from pursuing proceedings in another country. But these injunctions were originally used by the English Court of Chancery to prevent proceedings in or prevent the enforcement of judgments procured in the English courts of common law. That practice inevitably gave rise to tensions between the two courts, and in 1615, these tensions erupted in a huge battle between the head of the common law courts, the Chief Justice of the King's Bench, Sir Edward Coke, and the head of the Chancery courts, the Lord Chancellor, Lord Ellesmere, or if it's easier to imagine, the head of the Commercial Court and the head of the Chancery Division. The dispute arose as a result of a case in the King's Bench in which, to quote an academic article on this topic, the reference to which is on the slide, the claimant had secured a favourable judgment by inveigling the defendant's main witness to a tavern to drink when he was supposed to testify, and telling the judge that the witness was not at court because he was deathly ill. Chancellor Ellesmere granted the defendant an injunction to restrain enforcement of the King's Bench judgment that had been procured in this way, and in response to the grant of that injunction, Chief Justice Coke tried to have everyone involved in the injunction indicted for violating the statute supreme in Euro. This all resulted in a commission being appointed by the King, which concluded that the injunctions granted by the Courts of Chancery against the common law courts were lawful. So that's Chancery Division 1, Commercial Court nil. The court's jurisdiction to grant anti-suit and anti-enforcement injunctions having been confirmed, the subsequent history records the target of these injunctions widening out from the common law courts to the Scottish courts in Bushby and Monday, the Irish courts, as in Lord Portarlington and Solby, and then courts all over the world, although, as Stephen will go on to explain, until very recently, the courts of the European Union comprised an important lacuna to this jurisdiction. So much then for the history of anti-suit and anti-enforcement injunctions. Where have we ended up? In other words, what are the currently applicable common law principles? If I could have the next slide, please. While I've been talking a lot about common law principles, the jurisdiction to grant anti-suit and anti-enforcement injunctions is actually a statutory one. On whatever basis the injunction is sought, the jurisdiction to grant it derives from Section 37(1) of the Senior Courts Act. As will be clear from the wording of the statute on the slide, the statute confers a discretion on the court. So the question is, when will that discretion be exercised? The touchstone, as with any discretionary remedy, is what the ends of justice require. But that only takes us so far, and there are, in effect, two main categories of case where an anti-suit or anti-enforcement injunction may be granted. The first is where the respondent has invaded or threatens to invade a legal or equitable right of the applicant and is amenable to the court's jurisdiction for the enforcement of that right. And the examples of this category of case are generally cases involving exclusive jurisdiction agreements. The second category is where the respondent is pursuing or seeks to pursue vexatious or oppressive proceedings. And it's worth looking briefly at each of these categories in turn. If I could have the next slide, please. The first category, as I mentioned, concerns the case where the applicant has a legal or equitable right not to be sued except in a particular place or pursuant to a particular procedure, an exclusive jurisdiction clause. The key point to remember in respect of this category is the following. Where the parties have agreed this kind of clause, and a claim falling within the scope of the exclusive jurisdiction clause is brought in a forum other than that which the parties have agreed, the court will generally grant an anti-suit injunction unless the respondent can show strong reasons why it should be permitted to proceed in a forum other than the contractually agreed forum. And the authority for this is Donoghue and Armco. That case concerned a jurisdiction agreement, but the same holds true in respect of arbitration agreements. And as to these, the other case on the slide, the Angelic Grace, established the much cited principle that where an injunction is sought to restrain a party from proceedings in a foreign court in breach of an arbitration agreement, the English court need feel no diffidence in granting the injunction, provided that it is sought promptly and before the foreign proceedings are too far advanced. And that last passage is one we'll come back to shortly in the case of anti-enforcement injunctions. But the obvious question that arises is what will count as strong reasons, as a result of which the court will decline to grant an injunction to give effect to an exclusive jurisdiction clause. The example most commonly given is that of multi-party or multiple proceedings. In fact, that example was given in Donahue and Armco. And another common barrier to anti-suit injunctions derives from the caveat I mentioned in the angelic grace dictum, provided that it is sought promptly and before the foreign proceedings are too far advanced. We'll return to that in a moment, as I mentioned. So much then for that first category of case, the protection of right case. If I could have the next slide, please. The second category of case, as mentioned, is the case where the proceedings being pursued or threatened are or would be vexatious or oppressive. An important preliminary point to note here is the one in the first bullet point, which is that the question whether the foreign proceedings are vexatious or oppressive is a threshold question of evaluation. Afterwards, so after you've determined that threshold question, that's when the discretion comes into play. The assessment of vexation or oppression, in other words, is not itself a discretionary question. But how will the court go about assessing that threshold question? When will foreign proceedings be treated as vexatious or oppressive? And in general, perhaps obviously this is going to require a case-by-case assessment. But there is some judicial guidance in respect of certain categories of alleged vexation. So, for example, when foreign proceedings are said to be vexatious on foreign non-convenience grounds, it's been held that it's generally necessary to show that England is clearly the most appropriate forum, and that justice requires that the claimant in the foreign court be restrained from proceeding there. But in general, as I say, the question of vexation is going to be a case-by-case assessment. And as I mentioned, once that threshold of vexation or oppression is reached, there's then a further question as to whether the court should exercise its discretion to grant an injunction. And at that stage, the court will take into account any relevant factors, including comity. If I could please have this slide on anti-enforcement injunctions, the next slide. As the name suggests, these injunctions serve to prevent a party enforcing a judgment procured from a foreign court. And anti-enforcement injunctions operate on essentially the same basis as anti-suit injunctions, but they're granted much less frequently. And this is primarily because they involve a much greater interference with comity than do anti-suit injunctions. Now, anti-enforcement injunctions, as I say, are granted on essentially the same principles as anti-suit injunctions. So in the very scant back catalogue of successful anti-enforcement injunction cases, you will find examples of injunctions granted to enforce compliance with a contractual jurisdiction clause. That's the Ellerman Lyons case and the Banks and Petersburg case, and injunctions granted on the basis that enforcement within this jurisdiction of a foreign court's order would be vexatious. That's the SAS Institute case. But those three cases comprise near enough the sum total of successful anti-enforcement injunctions in the reported cases. So why is there, in the words of Christopher Clark, Lord Justice Christopher Clark and Ecobank Transnational, such a dearth of examples? Why are these anti-enforcement injunctions so few and far between? The answer lies in something inherent in these types of injunctions, which is that by definition, they're sought at a point where the foreign court has already accepted jurisdiction, dealt with the claim, and given judgment. And as I mentioned earlier, it's that critical caveat in the judgment of Lord Justice Millett in the Angelic Grace. The English court need feel no diffidence in granting the injunction, provided that it is sought promptly and before the foreign proceedings are too far advanced. Why is this temporal element so important? The answer lies in, firstly, general discretionary considerations, and secondly, the need for comity. The general discretionary considerations are obvious, a matter of prejudice mainly to the respondent. The application is often one of the core discretionary reasons. But what about the case where, for whatever reason, the respondent has suffered no prejudice, or that prejudice should not be taken into account? Now, even in that case, the delay involved in seeking an injunction until after the end of proceedings is still of critical importance, notwithstanding the absence of prejudice, for reasons of comity. And this point was addressed in detail in Ecobank, in which the applicant's delay provided the basis on which his application for an anti-enforcement injunction was refused. So by way of very quick summary, when can you get an anti-enforcement injunction? Well, the decided cases offer at least some pointers. So in Ellerman Lyons, the judgment of the Turkish court had been obtained by fraud, In Bank St. Petersburg, the parties had reached an agreement after the relevant judgments had been obtained that they would not be enforced and that their dispute would be tried in this jurisdiction. And in SAS, the court only restrained the enforcement of limited parts of the judgment of the North Carolina courts. So with that whistle-stop tour of the common law principles applicable in respect to anti-suit and anti-enforcement injunctions, I'll now hand over to Sir Richard and then Stephen.
Thank you very much indeed, Jacob. So last but by no means least, we come to Stephen Midwinter QC. Stephen is a very well-established silk in Brick Court Chambers who specializes in international commercial cases, and he deals in particular with jurisdiction battles and anti-suit injunctions. Stephen, over to you.
Thank you, Sir Richard. The problem that I suspect we all know has existed for the past 20 years or so is that it hasn't been permissible for the English court to grant anti-suit injunctions that have the effect of restraining proceedings in another member state of the EU. And the problem arose as a result of the decision of the Court of Justice in Turner and Grobbett. The facts of that case were that Mr. Turner was an in-house solicitor employed in the UK. He relocated to an office in Madrid because he wanted to learn Spanish, but after a few weeks there resigned, claiming to have found evidence of widespread fraud in the company. He returned to England and started unfair dismissal proceedings in the Employment Tribunal, where he succeeded. In revenge for that, his former employer started proceedings against Mr. Turner for breach of contract in Spain. The issues claimed in Spain would have been relevant to their defence in the Employment Tribunal proceedings, and it was held all throughout the English leg of these proceedings that the Spanish proceedings were brought in bad faith, were vexatious and oppressive, designed to punish Mr. Turner for what he had done. Mr. Turner applied for an anti-suit injunction against Mr. Grobbett, who was the controlling influence behind his former employer. The argument was raised that an anti-suit injunction would be inconsistent with the Brussels Convention, which was the applicable treaty at the time, but the position would be same under the Brussels regulation. The argument was that it prevented the Spanish court from considering its own jurisdiction, and that was inconsistent with the jurisdictional rules set out in the Convention and the regulation. The English courts up to the House of Lords said that that was wrong. Firstly, there's nothing in the Convention or the regulation which says that you can't restrain abusive proceedings being brought in another member state. And secondly, it involved a misunderstanding of English law. An anti-suit injunction doesn't prevent a court from ruling on its own jurisdiction. It's directed at a litigant who is acting in breach of contract or in an abusive fashion. And so we can see on the slide, Lord Hobhouse, setting out the reasoning of the House of Lords, said that if the matter were for English law, an anti-suit injunction could be granted, but he recognised that there was an issue of interpretation of the Convention that was referred to the Court of Justice. Next slide, please. The matter was then referred to the Court of Justice, which in what may be one of the most irritating examples of the poor quality of some of its decisions, held that anti-suit injunctions couldn't be issued against courts of a member state. And we can see what passes for the reasoning of the Court of Justice set out on the slide. It's from paragraph 27 of the judgment. It's really the second sentence there. Any injunction prohibiting a claimant from bringing an action must be seen as constituting interference with the jurisdiction of the foreign court, which as such is incompatible with the system of the Convention. That's reasoning which might lead some who read it to ask why and on what basis, but no explanation is given in the judgment. The reality seems to be that the Court of Justice felt that it was rude for the courts of one member state to restrain proceedings before the court of another member state. And so the argument that was had in England in the 1600s between Lord Ellesmere and Chief Justice Cook troubled the Court of Justice. And they reached the opposite conclusion, that it was simply too rude for one court to say that proceedings before another court ought not to go ahead. The effect of that, of course, is that the bad faith, vexatious and oppressive proceedings commenced by Mr. Grobbett in Spain were allowed to go ahead, and Mr. Turner was subjected to the vexation and oppression directed at him. One might wonder whether that was a just result. Occasionally, when I'm feeling particularly down about the consequences of Brexit, I think about this case, and it does tend to cheer me up. There's no doubt that the reasoning in Turner applies to cases also involving jurisdiction clauses, though there wasn't in fact a jurisdiction clause in that case. It was one brought on the bad faith, vexation and oppression ground. As you can see in the slide, the English court found some ways to limit the harm caused by the Turner decision in cases involving jurisdiction clauses. In the Alexandros T, it was held that the English court could grant specific performance of a jurisdiction or arbitration agreement in favour of England, and damages for breach if foreign proceedings were pursued. In that case, the facts were fairly extreme. The foreign proceedings were in Greece, but it was also applied on less extreme facts in the Barclays case, where proceedings were started in breach of a jurisdiction agreement in Italy. Next slide, please. There was then a question as to whether the same reasoning would apply where foreign proceedings were brought in an EU member state in breach of an arbitration agreement. The answer was pretty obvious from the reasoning in Turner, but in the front comor, the House of Lords, more in hope than expectation, suggested that maybe arbitration might be in a different category. That was shot down by the Court of Justice when the matter was referred. When the Brussels regulation was recast, the recitals were changed to give additional prominence to the importance of upholding arbitration agreements. And it was suggested, first by the Advocate General in the Gazprom case, which is referred to on the slide, and then by counsel in the Norrie Holdings case, that might mean that a different approach was appropriate under the recast regulation, and that anti-suit injunctions could be granted in support of arbitration agreements under that new regime. That was held by Mr. Justice Mayles to be wrong. What can be done, as was made clear in the Gazprom case, is that a court can grant enforcement of an anti-suit injunction ordered by arbitrators. So in the Gazprom case itself, there was an arbitration agreement in favour of Sweden. A government brought proceedings in Latvia in breach of that. The arbitrators granted anti-suit relief, and the Swedish court enforced that anti-suit relief against the proceedings in Latvia. The argument might be made, and indeed was made in the Norrie Holdings case, that given that that can be done, how can it make sense that the court can't directly grant anti-suit relief? But that argument was rejected. And so the position has been, up until the end of last year, that the English court cannot grant anti-suit relief or anti-enforcement relief against the courts of another EU member state, whether those proceedings are brought vexatiously or oppressively, or in breach of a jurisdiction or arbitration agreement. Next slide, please. What is the position now? Well, on the face of it, the common law applies across the board. As Charlotte said, the Brussels and Lugano regimes are no longer the law in this country, and so there is, on the face of it, no reason to treat the courts of other EU member states differently from the courts of any other jurisdiction. And so one might think, prima facie, the position would be just as the English court can grant anti-suit relief against proceedings in courts in the United States or any other country, it can do so in respect of proceedings in EU courts. If the EU joins or rejoins the Lugano Convention, the position will be more complicated. As far as I'm aware, Turner has not in fact been applied in any case directly decided under the Lugano Convention. However, it is pretty obvious that if the matter were referred to it, the Court of Justice would reach the same conclusion, that anti-suit relief is inconsistent with the Lugano Convention. What will that mean if the UK rejoins Lugano? Well, it's not totally clear. It wouldn't be EU retained law, so we wouldn't be bound by decisions of the Court of Justice. Formally, the English courts were required to take due account of decisions of the courts of other member states under the Lugano Convention, under what was Section 3B of the Civil Jurisdiction and Judgments Act, which has been repealed. Presumably, that would be reinstated if we rejoined Lugano, and so the English courts would be required to take due account of decisions of the Court of Justice, including Turner. Does that mean that the English courts would follow Turner and West Tankers and hold that anti-suit injunctions can't be granted under the Lugano Convention? Well, I don't know. There would obviously be arguments that that ought to happen, that there ought to be consistency of interpretation between different state parties to the convention. But on the other hand, the House of Lords made clear in both cases that as a matter of English law, there was no inconsistency between the convention regulation and the granting of anti-suit relief. Given the paucity of the reasoning of the Court of Justice in Turner in particular, one does wonder why the English court should feel constrained to apply it. Putting the matter the other way round, now that we are supposedly dealing with each other as sovereign states, one wonders whether the Court of Justice would feel itself bound to follow the House of Lords reasoning in Turner and in West Hankers, and one rather suspects the answer would be no. And if it applies that way, one wonders whether the same reasoning ought not to apply the other way. There would, I think, be a slightly different argument in relation to anti-enforcement injunctions if the UK were to join Lugano, because Lugano does set out a regime for mutual recognition and enforcement, and there would be a stronger argument that it would be inconsistent with that regime to grant an anti-enforcement injunction. But it seems to me the arguments in favour of still allowing anti-suit injunctions are fairly strong. There is a suggestion, some would say, that the Hague Convention would also prevent the granting of anti-suit relief in support of choice of court agreements. Article 6 of the Hague Convention sets out the obligations of a court not designated by the choice of court agreement, and it might be argued that by parity of reasoning with Turner, the court not chosen ought to be allowed to decide how to apply Article 6 and how to decline jurisdiction for itself rather than facing an anti-suit injunction. On the other hand, Article 7 of the Hague Convention explicitly excludes from its application any interlocutory relief, which might be thought to include anti-suit injunctions. It seems to me that the argument in favour of prohibiting anti-suit injunctions under the Hague Convention are rather weak. The argument that one ought to adopt the same approach as is adopted by the Court of Justice under the Brussels regulation is not a strong one. The Court of Appeal in the recent case of Etihad and Flirther, which was referred to by Danny in his slides, rejected a submission that the Hague Convention and the Brussels regulation should be interpreted always consistently. And it seems to me that, particularly given that non-EU parties are signatories to the Hague Convention, the argument that anti-suit relief ought to be restricted under the Hague Convention is not an attractive or strong one. So there is a very real possibility that English courts will start granting anti-suit injunctions against proceedings in EU member states. What will the reaction be? Will there be jousts? Will there be conflict between the English and EU member state courts? But of course, we don't know what the reaction will be. One's gut instinct, reading Turner, is that because anti-suit injunctions are not known in continental legal systems, there will be a reaction against them. On the other hand, there are indications that courts in EU member states might be warming up to the idea of anti-suit relief. There's a reference on the slide to two fairly recent decisions in patent cases, which are drawn from the blog cited there. In the first of them, the Munich Court of Appeals granted anti-suit relief in a dispute between Nokia and Continental. The facts were that Daimler was using Nokia phone technology on cars in Germany. Nokia sued it in Germany for patent infringement. Continental, which is Daimler's global parent, launched proceedings against various phone companies, including Nokia, in the US for alleging anti-competitive conduct and demanding FRAND terms for the technology. Continental obtained an anti-suit injunction in the US. Nokia applied for and obtained anti-suit relief in Germany, prohibiting Continental from enforcing that anti-suit injunction against the German proceedings. And the German court considered that Nokia's patent rights in Germany would not be sufficiently protected by the US proceedings, and there was a separate interest in proceeding with the case in Germany. In the Court of Appeal of Paris case, that was a dispute, again, a patent dispute between Lenovo and IPCOM. Again, Lenovo was suing in the US for global FRAND terms. In the meantime, IPCOM sued in France for royalties due under a license between the parties. The US court granted a worldwide anti-suit injunction prohibiting IPCOM from enforcing its patent anywhere in the world while the FRAND dispute was litigated. The French court again granted anti-suit relief, holding that that injunction could not stop IPCOM from suing in France for royalties under its French licensing agreement. The report of the case says that the French court held that French public policy does not recognise the validity of an anti-suit injunction except where its purpose is to enforce a contractual jurisdiction clause or an arbitration agreement. Now, on the face of it, that suggests that the French court might be willing to recognise anti-suit relief as a legitimate tool to support a jurisdiction agreement or an arbitration agreement. And while some might view these cases as suggesting that there's going to be conflict ahead, with anti-suit relief being granted in England and anti-suit relief being granted in France or Germany, it seems to me actually that if one thinks a little deeper, there's cause for some optimism. It seems to me to be a positive development if the courts of EU member states recognise that there is a place for anti-suit relief, particularly in support of jurisdiction and arbitration agreements. The EU's hostility to date has largely been a result of the familiar pattern of people being hostile to something that they don't understand. Greater use and understanding of anti-suit injunctions as a legitimate tool of the court seems to me to be something that should be welcomed. And it should also be noted that in those particular cases, the US court had granted anti-suit relief on a basis which was much broader than the English court would ever have granted it on. There was no suggestion of vexation or oppression or breach of a jurisdiction agreement or arbitration agreement. I very much doubt that an English court would have granted anti-suit relief in those cases. And so if the English court only grants relief where there's been a breach of a jurisdiction agreement or an arbitration agreement or where there's bad faith or vexation, it seems to me to be much more difficult for a litigant to go before the court of an EU member state, make a good case for an anti-suit injunction. And one can envisage it. The litigant goes to the French court and says, I promised to sue in England, proceedings are underway in England, but I want to continue my proceedings in France. One would hope that the French court would say, why? Why should I grant you an anti-suit injunction in those circumstances? Go and litigate in England where you promised to litigate. And if they're not prepared to do that, then perhaps the English court needn't worry too much about the sensibilities of the foreign court and should do justice and grant anti-suit relief to prevent parties from committing what is, in these cases, a breach of contract, just like any other. But as I say, overall, I am optimistic that provided that anti-suit relief is used and granted properly by the English courts with caution in the right cases, that courts of the EU member states will not react in the way that some predict, finding it an affront to their dignity, but will instead recognise that the injunctions are intended to serve the aims of justice and that we can move on in a grown-up way. And that was all I had to say about that.
Thank you very much indeed, Stephen.